Welcome to this unidentified channel. Today we are going to pick back up where we left off in reading the order that disqualified Mark Means as Lori Vallow Daybell's attorney, and we're starting right now. We read through 4 pages of the 17-page order in the last video, so I'm going to pick back up where I left off and just read through the rest of this so we know what the order says. Alright, if you're following along, it's at the bottom of page 4, and we're going to pick up with, there's 3 words on page 4, and we're going to page 5, so here we go. That Mr. Means represented Vallow at that time is also clear, as noted by the previously referenced notice of appearance filed in her case. Now, if you haven't watched the first video, I'll just put a link right here real quick because you'll want to listen to that before moving on. We're on page 5, so get the first 4 pages first. So here we go. Daybell also stated he was eventually going with the other guy, ostensibly referring to Mr. Pryor. After that call, on or about May 1st, 2020, a bail hearing was held in Vallow's case. At that hearing, Mr. Means represented to the magistrate judge that he represented Daybell as well as Vallow. Thereafter, on June the 9th, 2020, a search warrant was executed on Daybell's property that led to the location and recovery of the bodies of Vallow's 2 children. The state submits that upon law enforcement's arrival at Daybell's property, Daybell called Mr. Means and asked law enforcement officers to speak with Mr. Means about the warrant. It is undisputed that Daybell called Mr. Means. However, after its in-camera inquiry of Daybell, the court determines that there is a dispute about the content of the call. Daybell was arrested that day in connection to the ongoing investigation into the death of Vallow's children and charged with felony counts in case CR 22-20-75. On or about June 30th, 2020, Fremont County Magistrate Judge Edens inquired of Mr. Means whether he had ever represented any co-conspirator listed in the complaint attached to the Fremont County case CR 20-0838. Mr. Means denied that he had represented anyone other than Vallow. His position was unpersuasive, and Judge Edens found that Mr. Means had represented both Chad Daybell and Lori Vallow Daybell. Judge Edens ruled that there was a conflict of interest stemming from Means' concurrent representation. However, Judge Edens concluded that given the nature and tenor of the specific charges in that case, the conflict was waivable, provided the defendants furnished valid waivers to the court. Judge Edens expressly stated his order accepting the waivers was limited to the proceedings in CR 22-20-0838. There is some question about the validity of the waiver Mr. Means furnished to the court. Ultimately, it is not dispositive to the issue of conflict in the present case and need not be discussed further at this time. On March the 2nd, 2021, Mr. Means filed a request for Vallow to be evaluated pursuant to Idaho Code Section 18-211 and submitted the bill on the examination to Fremont County. The state challenged that action because Vallow had not been declared indigent. On May the 21st, 2021, this court determined Vallow was unable to pay for the evaluation and Vallow was declared indigent. On May the 24th, 2021, a Fremont County grand jury returned an indictment charging Chad Daybell and Lori Vallow Daybell as co-conspirators in the deaths of Tylee Ryan, J.J. Vallow, and Tammy Daybell. The charges for murder in the first degree carry maximum penalties of death. On May the 26th, 2021, the defendants appeared in magistrate court in Fremont County for an initial appearance. Daybell appeared with his counsel, John Pryor, and his case was set out. Before Vallow was set to appear on the record, the court determined Vallow had a pending Idaho Code 18-211 evaluation, and that because her competency was in question in another case, the state's request for counsel to be appointed would not be considered at that time. On June the 8th, 2021, this court found Vallow not competent to stand trial and remanded Vallow to the Department of Health and Welfare for treatment to attempt to restore competency. On July the 27th, 2021, under seal, the state filed its motion objecting to the appearance of Mr. Means in the case and raised several issues, including the concern that Mr. Means was not death penalty certified counsel and that as a declared indigent, Vallow had a statutory right to appointed counsel. Accordingly, the court appointed R. James Archibald to serve as co-counsel to Mr. Means while the court assessed the conflict issue raised by the state. Acknowledging that Vallow's case was stayed on account of her treatment to restore competency, the court nevertheless held a hearing where counsel for both Daybell and Vallow were present on September the 8th, 2021, and ordered Daybell to appear for an inquiry to resolve the conflict issue. Daybell and his attorney, Pryor, submitted to this court on October the 8th, 2021 for an in-camera inquiry. Meanwhile, Mr. Means has continued to file pleadings in Vallow's case CR 22-21-1624 as sworn declarations signing his name under penalty of perjury to attest to facts that Mr. Means has furnished to the court. Notably, Mr. Means filed a declared motion on October the 27th, 2021, where Mr. Means conveyed information he obtained from his client, Vallow, as the declarant and swore under penalty of perjury the veracity of the statements contained therein. Legal authority. 1. Duty of inquiry. The court has a duty to inquire about attorney conflicts of interest when it is made aware of particulars of one. Whenever a trial court knows or reasonably should know that a particular conflict may exist, the trial court has a duty of inquiry. This inquiry is required when the court knows or reasonably should know that a particular conflict exists, and is not to be confused with the court being aware of a vague, unspecified possibility of conflict. If the court determines that an inquiry is wanted, the court's inquiry must be both searching and targeted at the conflict issue. Failure from the court to conduct an adequate inquiry can serve as a basis for reversal upon appellate review. 2. Sixth Amendment rights. The Sixth Amendment of the Constitution guarantees a criminal defendant the right to legal counsel. The right to counsel was applied to state prosecutions for felony offenses through the incorporation doctrine. The right includes the right to effective assistance of counsel, which is determined by a two-pronged test. To prove ineffective assistance of counsel, a defendant must show, 1, their lawyer's performance fell below an objective standard of reasonableness, and 2, a reasonable probability that, but for counsel's unprofessional efforts, the result of the proceedings would have been different. Case law demonstrates that an attorney conflict of interest can lead to ineffective assistance of counsel. This occurs if a defendant's lawyer actively represented conflicting interest, and that an actual conflict of interest existed and adversely affected the lawyer's performance. Included in the Sixth Amendment right to counsel is a defendant's right to choose his or her counsel. However, while the right to select and be represented by one's attorney is comprehended by the Sixth Amendment, the essential aim of the amendment is to guarantee an effective advocate for each criminal defendant rather than to ensure that a defendant will exonerably be represented by the lawyer whom he prefers. Representation of more than one criminal defendant in a case endangers special dangers which a court must be aware, as it could interfere with effective assistance of counsel. The right to one's counsel of choice is not absolute, though it will only be disturbed in the most extraordinary of circumstances. Thus, this court recognizes the defendant has a Sixth Amendment right to counsel and, presumptively, the right to counsel of her choosing. However, the court must also balance this right with the right to effective counsel, which can be threatened by an attorney conflict of interest, as well as the effective administration of justice through a fair and orderly proceeding. A. Conflict of interest. The decision to grant or deny a motion to disqualify counsel is within the discretion of the trial court. Weaver v. Millard, 120 Idaho, 692, 697, 819, P. 2D, 110115. The moving party has the burden of establishing grounds for the disqualification. Where a motion to disqualify comes not from a client or former client of the attorney, but from an opposing party, the motion should be viewed with caution. Rule 1.7a of the Idaho Rules of Professional Conduct states, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if, 1, the representation of one client will be directly adverse to another client, or 2, there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by the personal interest of the lawyer. Rule 1.7b states that even if a concurrent conflict of interest exists, a lawyer may represent a client if, 1, the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. 2, the representation is not prohibited by law. 3, The representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before the tribunal. And 4, each affected client gives informed consent confirmed in writing. To proceed forward, the court must determine 1, whether it knows or has reason to know that a conflict exists, 2, whether an actual conflict of interest exists, and 3, if a conflict exists, is it waivable in the present case. I'm going to wrap up there. We are in the middle of page 10, going to start on the analysis. It will be the first thing that we start in the next video, and hopefully I will be able to get it all wrapped up in the next one, hopefully. So just be on the lookout. Again, as soon as it's ready, I'll post it above and you can just click on it. If it's not there, it's not ready yet, I'm working on it. Yeah, it's flashing at me. So I appreciate you all for being here, and I will see you next time. So the last, all right, I'm going to try not to shake the desk this time. All right. It is when it, yeah. Okay. Lori Daybell. Yeah. Lost my place. An attempt to restore competency. Where does it say that? -08. The representation does not involve the assert on May the 26th, 2021. The defendants. I am. Yeah. Okay. So this occurs if a defendant's lawyers, and that as a declared indigent, his position, okay, here we go, out of breath. All right. Right here we go. Whenever a trial court knows when it is made aware of particulars of one. What the heck, man? Get out of here with that. The court has a duty to inquire about attorney stemming from Mr. Judge Edens found that Mr. Means had. Ultimately, it is not dispossessed. I'm going to pause you for a second and see what's left here. So maybe we can get it done in 3. Yeah, we're on. Okay. All right. I am going to wrap up there. We are on the... Okay. Let's see. All right. I'm going to start back at... No, let's just do this. Bye.